My name is Sam. I'm the Partnerships and Communications Manager here at Fairygodboss, and Fairygodboss is the largest career community for women. Our mission is to improve the workplace by increasing transparency, and we offer a ton of great free resources like anonymous company reviews, job listings, articles, virtual recruiting events, and so much more to help you succeed in your careers. We will be taking questions at the end of today's webinar and throughout if they pertain to the conversation at hand. So feel free to leave them in the Q&A. You can leave questions as yourself or anonymously. Can't speak today. And I know that some of the topics might be something you don't want to attach your name to, so feel free to ask whatever comes to mind. Just make sure you toggle that anonymous button. You can also leave comments, talk with others in the chat. And we'll be recording today's webinar and sending it out in a follow-up email later today. So if you miss anything and you want to rewatch it back, you'll have the ability to do so. Here with me today is Claire Cochran. Claire is the founder and principal at the law offices of Claire Cochran in San Francisco, specializing in plaintiff's labor and employment litigation. She worked for years at large law firms on both the plaintiff and defendant sides of labor and employment law. And throughout her decades of practice, she saw that the unique needs of women, non-binary, and LGBTQ+ communities in particular were not being skillfully addressed by existing Bay Area law firms. So she did what any strong woman does, and she created her own. Thanks so much for being here today, Claire. Over to you.
Great. Thank you so much for that nice introduction. I just want to give a little bit more background. I've been practicing for about 20 years in the San Francisco Bay Area. We have cases all over the state of California, and we actually have cases in New York and in Massachusetts right now. So we practice across the United States in federal court level cases and do primarily state court cases, but we've also done cases in Washington, we've done cases in Oregon, we've done cases in other different states. So we haven't reached Finland yet. I can see somebody is on here from Europe, but certainly I think that the guidelines that I'm going to talk about today are applicable to people, at least that live in the contiguous United States, generally speaking. Some states have better protections for individuals in the workplace, specifically women and other underrepresented groups. Some actually don't. Some actually have not as good of law, but there are also federal provisions that will oftentimes protect us. With that said, the guide that we're going to be discussing today that you can see here on the screen is something that I think applies to anyone who's actually trying to advocate for themselves in the workplace. And we're going to talk about a few things today that I've learned from my practice. And I think I even might have a client or two that's on here as well today, and those people perhaps anonymously can chime in if they want to add information about the way that they experienced harassment, retaliation, or discrimination in the workplace, and the way that what I advise them to do helped them set themselves up for success. And what I mean by success is, you know, what I really like to do is help people resolve these actions prior to litigation. Litigation requires a public announcement in the form of a civil complaint of your allegations against an employer. And as we all know, later employers don't really want to deal with that or see that. And a lot of times I have experienced that as a way that people are repressing the rights of underrepresented individuals is by scaring them out of actively filing litigation. And I'm here to tell you that there are things that we can do before we get to litigation that can advocate for you and empower you against your employer, and also allow you to reach success, whether that's leaving the company or that's staying on at the company, but really changing the way that you're being treated there. Okay, so the first thing we're going to talk about today is something that, and I also want to let everybody know, I am on the front lines of dealing with COVID-19 and how it's affecting employees. And so I'm going to be peppering in some of that discussion today, which is outside of my normal talk. Normally I'm talking about just our natural, normal environment of going into work, but I will at the very end of today's talk discuss more about what I'm seeing in the way that coronavirus is affecting employer and employee relationships. And I may sometimes touch on it here, simply because it feels like it's necessary right now. The way that we're going to start this is by talking about how we identify retaliation, harassment, and discrimination in the workplace. And this is not a major legal discussion or point. This is actually about how you feel mentally and emotionally at your job. And I have discovered by working with a vast array of clients over the years that there's always a physical and mental and emotional sign of mistreatment. And we can talk about some physical symptoms that my clients have displayed over the years. Insomnia, migraines, panic attacks, vomiting before going into work meetings, stomach upset, inability to eat, overall anxiety, fatigue, being diagnosed with depression or anxiety or fatigue, ending up in emergency rooms. I don't know if any of you, can raise your hand anonymously in our chat here, but I think that I don't think I know that these are very real reactions to discrimination in the workplace. And what that means is that we all begin to feel it, at least in our bodies, mentally and emotionally, when somebody's mistreating us in a way that is more likely than not going to be considered harassment or discrimination. So we've talked about some external signs physically. We have the internal signs, which are mentally and emotionally feeling out of control, feeling a significant measure of fear when it comes to interacting with a person or senior level management at your company. That's not normal. Of course, intimidation and struggles in the workplace happen with the business aspect of the rat race. However, being paralyzed with fear before going in to talk to a manager or senior level employee is not normal. Okay, and I always tell my clients that one of their favorite things about talking to me and getting some resolution is the fact that they are being validated in their feelings, because people begin to feel like they are quote unquote crazy. I hate to use that word, but it's a word that's used to gaslight many of us out of how we are feeling physically and emotionally, and really taking that to the employer or taking that to somebody else for some self-care there. Okay. So first of all, here we are, we're sitting here together, and we've all evaluated the way we're feeling, and we're saying to a friend or a family member, gosh, I feel terrible about going into work. I feel like I'm being punished for things I haven't done. I feel like it's unfair. I'm feeling sick. I'm feeling nauseous, all the things we've just talked about. So then we go to the second level of analysis, which is taking a step back and asking yourself, what has happened recently at my job that could be creating this environment for me? And there are a variety of different topics that are protected by the law. And there are different things that you can look to yourself and say, and I have made a list of here that they're not all inclusive, but are just some examples of things that are protected against retaliation. Are you pregnant now, or have you recently taken a related leave? I will say anecdotally, I also have had clients who have been discriminated against when they talk to a boss or about having a miscarriage, or talk to a boss about trying to get IVF or other types of fertility treatment. Those all can be considered what we now currently call gender discrimination, because it is related to the idea that only a woman at this point in time could bear children. But that's not a point we need to belabor right now in this conversation. You can also be discriminated against as a male or any other type of identifying individual if you are talking about your parental status in the workplace. So if you were talking about your spouse or significant other attempting to get pregnant or undergoing fertility treatment, and then the atmosphere at your job changes towards you, that is also protected. So these are all areas around that type of topic. So if you've recently made those types of announcements, that's something to consider. And also remember, sometimes discrimination is not overt. And what that means is you might have a boss or somebody above you who expresses concern over something like a miscarriage, but then uses that information against you later on, or has a desire to get rid of you because they're concerned about extended maternity leave or paternity leave or family leave. So those are things to consider. Second, something else that you can be discriminated against would be taking time off to care for an ailing parent or family member. I think a lot of us have heard of Fmla Leave before. That's the Family Medical Leave Act. That would also apply. Have you recently taken time off to care for a family member or child, somebody that's sick? Did you participate in any workplace investigations? I will say this is something that comes up with my clients a lot, because they forget, that they were advocating or helping a coworker deal with something like, advocating for a lactation room, even if they themselves are not currently lactating or trying to have children. or if they helped advocate for gender neutral bathrooms, or anything that touches on a protected class in the United States, which is race, gender, in most states, you know, gender fluidity and gender neutral discussions, diversity in terms of race and religion, anything that touches on that. If you even participate in advocacy for those things, if you participate in an investigation on behalf of somebody else, let's say you watched a coworker be touched at a, you know, work function inappropriately, and you advocated for that person or participated in that investigation, you yourself could be protected for retaliation that results from that. So a lot of times people don't understand that it doesn't have to be personal to you. Sometimes it can be personal to somebody else in the office, and you're just participating, you get protection. Under the Equal Pay Act, both federally and state-wise, did you recently ask about commensurate male salaries or compensation or equity plans? You know, there are specific protections against, for us to not be retaliated against for asking those types of questions. That's something to consider. There's also other things called whistleblower statutes, which would be comparable to saying to a boss or an employer, I'm not going to, you know, not record overtime for our hourly employees. I'm not going to, you know, misrepresent an individual in the office, or misrepresent numbers, let's just say, like on a cash flow chart. I'm not going to take direction that I feel is illegal or possibly against public policy. That's something else to consider. And I will tell you that is a real winner, I hate to use that term, but for a lot of my clients, which is many of the things we're discussing fit under whistleblower protections. So if you've gone against the company in any way, shape, or form about something that feels wrong to you, most of the time it is actually something that would be protected under whistleblower. And I can answer more questions at the end of this call about if you have specific examples of something that's happened to you, if it fits under whistleblower provisions. This is one I think really obvious. Did you rebuff sexual advances, or you know, or discourage sexual advances, or you know, something? I have a case right now where a woman just said, I wish people would stop watching pornography in the workplace, and then she was discriminated against because of that. You know, these are valid objections that you could make, but if you were retaliated against for making those objections or statements in the workplace, you may have a case for harassment, discrimination, or retaliation. Then we have what comes next, which is something called an adverse employment action. So now we have gone through two things. You are physically, mentally, and emotionally bereft. You know, currently you're having panic attacks. You're very stressed out about interactions with a particular person or persons at work. Second, you've looked at your recent history at your office place, and you've discovered that, yes, I was the person who kept raising my hand about the gender neutral bathroom implementation, or whatever it is that you've done that's made you a quote unquote workplace troublemaker. By the way, those are my favorite clients. I myself am a troublemaker, so, you know, 3 cheers to all of us. But if you have a recent troublemaker interaction with the employer, then now we get to the next step, which is called an adverse employment action. Adverse employment actions, you know, many people believe are simply being terminated. You know, that's like, oh, that's all it is. If I got fired, that's the only way that I have a case, and that's simply not true. You know, I lots of times like to reference the scene in The Office where they take the one of the employees that they don't like, and they put him in the basement of the office building with his red stapler, and he's basically banished. That is what we call an adverse employment action, and that means that anything that is done to negatively affect you in the workplace can be considered an adverse employment action. That includes moving you to a shitty desk. That includes putting you by a drafty door. That includes removing you from the office and making you work in the bullpit in a tech firm. These are all things that have been considered adverse employment actions under case law. And so even if it seems perhaps innocuous, but you know that it's terrible in a way that's different than other people would understand, you know, that can be considered adverse. Additionally, the obvious ones would be you are, you know, losing a promotion, or you are being terminated, or you're being set up for termination. A very popular tool that I see is what we call a wrongful pip, or a wrongful warning, which is, and you know what it is as the employee, which is you're progressing in your career normally, you're doing great work, you've had great performance reviews, then you have your troublemaker moment, and all of a sudden you are now getting a performance review for things that were not a problem 2 months beforehand, or are not a problem apparently for other employees. So that's another warning sign of discrimination and harassment, because they usually will have a process to get rid of employees. And just because you receive a poor performance review doesn't mean you're not being discriminated against. It doesn't necessarily mean it's about your work product. So, that's something to look at closely. We're going to talk about next steps. Okay, so now you've got, let's just say we're using this example that we've gone through today. You have your panic attacks. You're feeling very anxious at work. You've evaluated your recent history and you've discovered that, yes, I was a participant in this advocacy group, or I did push back against my boss about using the numbers that represented our work product wrong, something along those lines. Now, and then you have an adverse employment action. You were passed over for a promotion. You were told now you have to drive, out of the way another 50 miles to report to a different office. So your job isn't taken away, but there's added stress to your life. Those are adverse employment actions. Now we're at, what do we do? What do we do next? I'm gonna stop this share and just put it like this. What do we do next? Well, the first place to look is to look at the company's own tools, and that would be by looking at your employee handbook. The reason I suggest people look at their employee handbook is because 9 times out of 10, a company has put out there into the world a suggestion of like how radical they're going to be about investigating employee complaints of discrimination and harassment. And a lot of times they've actually made statements in their employee handbooks that are well above the standards that are actually mandated by the law. So the courts have shown that judges and juries, they just really hate it when the company can't even live up to its own standards. So the first thing that I suggest that people do is you go to your own employee handbook and you look through the employee handbook and you see exactly what the company is required to do in response to a complaint of retaliation or harassment. So, they're like, oh, we will immediately and promptly investigate fully any claims and conduct interviews and give you a report. Well, great, so let's get it done. And so what we do is we now move to connecting with human resources and our supervisor and taking that section of the employee handbook to them and saying, I feel like I'm being discriminated, listing out the things that we have already talked about here today. I am feeling sick and anxious. I had this interaction where I said no to my superior about him requiring me to change numbers on a report. And then I was then told I needed to report to the office in Santa Rosa when I typically work in San Francisco. And so I want to report a retaliation and harassment based on my interaction with my supervisor. And now I would like for you as the employer to conduct the investigation that you said you would do in this employee handbook. Now, I want to be clear and fair that I do think there are some good human resources employees and departments out there. However, we should all remember that they work for your employer. And so their job is to minimize risk and liability. And so what you need to do from the beginning of this timeline that we've discussed today is take copious notes constantly and save every email or document related to any of these interactions, including tracking when you started to feel sick, tracking the conversations that you feel like might be protected. We've talked about a variety of different areas now: race, religion, gender, sex, anything that you've done that you feel like is provoking the retaliation or harassment. Take notes about that, save emails, forward emails from your work computer to your personal email. Just, I will tell you from experience that when you start to become more of a troublemaker, if it's a huge worrisome issue for the company, sometimes they will shut down your internet and your emails because they're trying to limit their own liability and trying to deprive you of evidence. So you want to make sure that you're constantly saving all this information. So now we've looked at our employee handbook. We've shown them the money. We're like, here's what you need to do for me. Second, don't be afraid to use key terms. A lot of my clients come back to me and say, well, I said, I feel like I'm older, so maybe, I don't know. I'm like, did you say you're concerned that they're discriminated against older employees? 9 times out of 10, they say I didn't use the word discrimination. Now, under the law, they don't expect you to be lawyers and know how to do this. But I will tell you from experience that by using words such as retaliation and harassment, you are actually setting in motion requirements that are very specific, so that later on, if we had to, heaven forbid, litigate the case, we're not trying to pick apart what you were trying to say. Did you actually notify them of a problem? That becomes a hot button issue in litigation. Specifically, I will say this as a sidebar: if you have a disability and you have, maybe you're immunocompromised, maybe you have, I've had different clients who have, autoimmune disorders where they have migraines and they need a lot of accommodations. Please be very specific about disclosing your accommodations, that you're under the treatment of a doctor, that you have a disability that affects your ability to conduct life normally compared to a normal person. These are types of phrases that will get you a long way with regard to accommodations, and certainly will save you later if people act like you never disclosed a disability to them. So again, I can answer more questions about that after the talk is over. Okay, now we've talked about reporting to human resources. We've talked about the importance of taking notes, that and recording everything that's happening. That's extremely important for me. I will tell you that the courts have shown time and time again that contemporaneous note-taking, whether you write it down or you put it in your phone or you send an email to yourself, is considered the highest level of evidence when you record when something happens in the moment. So that a year later or 2 years later, if for some reason you had to, heaven forbid, be in litigation, your notes and recollections about what happened in a particular conversation will be more powerful than what a supervisor says they said 2 years later. All right, so we've gone down the list of what I typically suggest people do. If you are at the point where you have shown your company the employee handbook and their requirements, and if there is an employee handbook, you've Googled on the web, what are companies required to do to investigate harassment, and shown that to them. If you've been assertive in those ways and nothing has happened, it's probably time to contact an attorney, at the very least for a consultation, to figure out what the next best steps are. And at that point in time, you'll decide if you want to stay in this job or if you want to have an attorney come in and help you leave that job. So that's, I think that's all I have about this part of my talk. I was going to talk about some coronavirus things, but I thought maybe now would be the time to take any questions about this part of the talk, and then I can wrap up and talk a little bit about the coronavirus and employment law.
If you have questions, feel free to leave them in the Q&A. Again, you can toggle your question to make it anonymous. Currently, Claire, the question in there, I think, is actually more related to coronavirus and will kind of work well with that conversation.
Okay.
If anyone has another question, feel free to leave it now.
I see this. This is when I was furloughed a month ago.
Mm-hmm.
Okay, I can get to that in a minute. How do you know if they fully investigated the claims? Okay. Let's start with that one. How do you know if they fully investigated the claims? Well, I mean, I think that sometimes that is going to be in the employee handbook, but B, you ask them to tell you that they have and tell you the steps that they did. Imagine, let's just use today's example about the coronavirus. I order some lunch from somebody to be delivered, and I call them and I say, well, what safety precautions did you take? And they say, well, we took all of them. That's not a sufficient answer, right? The answer is, well, no, what steps did you take? Did you wash your hands? Is the produce cleaned? Did you wear a mask? What are the requirements that are in place in your place of business right now to make sure that you're being safe with your food? It's the same thing with your questions to human resources, which is, they have to come back to you and tell you what they did. Who did you speak to? Did you speak to or record any statements with my boss or supervisor? Did they take your statement? I mean, I think that's something that's really important. I've had cases where they're like, oh yes, we investigated the claim, but they never came back to you and fully talked to you about it. It's just like one conversation once where you say, like, I feel like I'm being discriminated against. And they're like, investigated, done. And you're like, that's not really how it works. This is where the recording of your thoughts and the interactions really come into play, which is like, when you talk to them on such and such date and they're telling you they're going to conduct the investigation, then you write that all down in your notes and you can respond to them and say, when I spoke to you on May 2nd, 2020, you told me you were going to conduct an investigation and you suggested at that time that this is what it would involve. Did you do these following steps? or what steps did you take following that conversation? This is very hard for clients. I will admit that I know that it's hard to be uber assertive to employers in these moments, but you have to continue to push back and do it to the best of your ability by doing constant communication, which is, this email will reflect our conversation we just had, wherein you told me you were going to investigate my claim that I saw Bob Jones touch, Sonia on her rear at the event last night, and I want to make sure that that gets documented and taken care of. I also will say, I'm not suggesting you contact a lawyer at this point in time, but I know my firm does something called ghostwriting, which is when people are very concerned about these moments and interactions, sometimes we'll step in and help them write those emails. This is not intended to get people in or out of a job. It's just intended to make sure that there's proper investigation and notice occurring. And sometimes clients just want us to write it. But if you don't have the money to pay for lawyers, this is a good way to do it yourself. Okay. Where would you place workplace bullying versus discrimination and retaliation? Okay, this is a good question. In the state of California, at least, and also in New York, we have concepts called negligent retention. I believe most states in the union have this cause of action. And it's really interesting. It originated actually from a case against a trucking company, because the trucking company was hiring people that had DUIs on their records. And of course, those trucking companies went out and killed people because they were people that actively had a history of drinking and driving. And it was about whether or not the trucking company was liable then to the people that they struck and injured. And the answer was, of course, unequivocally yes, which put this requirement on an employer to understand and know the risks of its employees. The way that I have successfully used this cause of action with clients with workplace bullying is by demonstrating that there's a pattern and practice of a particular employee, usually senior management, oftentimes men. I'm not saying it doesn't happen with women, it does too, but somebody who a lot of times the employer perceives to be like a rainmaker, or somebody who's very important, who has a pile of dead bodies behind him or her. In other words, like multiple people have quit or transferred out of this person's department because they're just such a nightmare to work with. Usually, and I'm not saying all the time, but usually I can find something in there that that person has done that's not just bullying, that's actually demonstrably discriminatory. Usually that's usually the case. It usually results in them mainly picking on people that are less powerful than they are. And I don't think that those people are less powerful, but usually it's against women, or it might be against people that are, non-binary. Like, these people tend to bully the same types of people, which is actionable. But under negligent retention, we can go after an employer for having someone in the workplace who is a known bullying person, is somebody who's known to cause destruction, to cause terminations, to cause people crying. I mean, and we can walk down that road more maybe on an aside, but you can definitely have workplace bullying as an action and that demands investigation. And most employee manuals do have sections about there not being bullying allowed in the workplace, and that will require an investigation. So in that way, the employee manual is up above, is going to be higher than what's required under the law. Okay, let me read the next thing. Okay, there's a lot here. Trying to figure out. Okay, so now should I go to the coronavirus? Here's what I'm gonna do. I'm gonna come back to the coronavirus ones and do the ones that aren't related to coronavirus first. Can you talk about what happens during investigations when situations escalate to HR, how HR typically talks with either my boss or my colleagues, and what you see there, specifically in larger corporations where they might even have a third-party service? I think that what you're asking me is if it's normal for a third-party firm to come in and investigate. The answer is yes. It does happen. It usually happens when the company is worried about you suing them. So it's going to happen in a bigger instance. In other words, like if there's a sexual assault or a massive whistleblower claim, that they will hire outside agencies. The way that I deal with those outside agencies is, of course, they're being paid by the company, so they're going to find really what they want them to find. But you'd be surprised, sometimes they actually do find that there's harassment and retaliation. So that is normal for them to do that. I will say this, as a labor and employment lawyer, if they're bringing in a third party, then your case is probably pretty decent. You should get a lawyer. That's a pretty hardcore reaction to a report of discrimination or harassment. Is it legal to video or phone record conversations with HR? Okay, it's state by state. In New York, yes-ish. In California, no. You need to, I would always ask permission. Surreptitiously recording things is just, it's not awesome. You just ask if you can record, and if they say no, ask why not. You know, push back on that. Or you can say, I'm going to record this conversation and just put it in front of them. But you do need to make an outward statement. I always recommend that to my clients. Okay. I spoke to HR at my last job about practices I didn't think were legal, and they said I would be covered under the whistleblower policy, but couldn't promise me security while it was going on, and that it would be bad for my company. So I left without submitting documentation. My question is, how much can you really be protected by that? Can you trust HR? I mean, this sounds like a legal question that I would have to know much, much more about. I'm going to go ahead and say that most companies have confidentiality agreements in place with their employees today, at least in where I work in Silicon Valley and the Bay Area and New York. Most companies have confidentiality agreements in place that discuss what you owe the company, certainly. And so under those confidentiality agreements, you can ask for that same confidentiality back towards you. Offhand, that seems like a strategy to get you to go away. I'd have to know much, much more about that. I can't, they couldn't promise me security. Yeah, that's a more specific legal question that would probably need to be answered offline. I'm sorry that you experienced that. Does HR have to divulge full details? The people asked have right for privacy too. Often people are afraid to talk as witnesses for this reason. Their name will be divulged. Does HR have to divulge full details? I'm trying to figure out to whom. All right, did you have a question, Samantha?
Nope, I was just gonna jump in with clarity, but feel free.
Okay, go ahead, Bill, go ahead. Go with clarity, go ahead.
I think she meant like the people as employees in general.
Right, I mean, I guess I don't know understand the question of does HR have to divulge full details? When they're conducting an investigation, to the extent that, I mean, let me be clear. We're asking questions that are outside, I think, the scope of the conversation here today, which is like, this is about self-advocacy in the workplace. These are specific questions. If you have a really big concern about privacy, let's just use that for example. I have a client who was sexually assaulted on the job. When she reported that to Human Resources, she quite clearly said that she didn't want anybody else in the company to know about it, and that the only people that needed to be talked to were the immediate witnesses to the sexual assault. She set those terms and those boundaries herself. Feel free to do that for yourself as well when you're talking to Human Resources. I will tell you that as a labor and employment attorney, if Human Resources does not abide by those restrictions that you're placing on the situation, that itself can be seen as discriminatory and retaliatory. The more that they do to make your experience terrible about something that you're reporting to Human Resources is evidence that what they are doing is discriminatory and retaliatory and will bite them in the butt later. So again, keep track of all this, which is in my conversation with Bob and Human Resources, I said specifically that outside of investigating this claim, I did not want any of my information to be proliferated in the workplace. And if he does it anyway, that's discrimination, okay? That's retaliatory. It's very bad for Bob. Okay, what happens when they say it comes down to, Samantha, were you indicating something to me? No, okay.
Nope, you're all set.
Okay, what happens when they say it comes down to he said, she said? Well, then your employer is not really doing much for you, are they? I mean, I think that that is a typical response of somebody who's trying to get out of actually investigating a claim and say, instead of saying, well, you say this happened and they said that happened. If you have a strong case, let me back up a little bit. As a labor and employment attorney, I will tell you that that practice of telling someone that what they said and reported is not valid simply because somebody else disagrees with them is not true investigation and is a method to gaslight you. In other words, like, continue to make the claims, continue to ask for the investigation, continue to see notes and reports, ask them more questions about, well, what about other people's experiences with that workplace bully? Have you talked to other people? You're going to need to just keep going back to the well and be persistent in your reporting. Now, I know this is shocking, but we don't always have claims. I mean, my famous line to clients is that I can't sue someone for being an asshole, meaning that bosses are oftentimes, and superiors are oftentimes, allowed to be jerks. If there's no protected action, in other words, like, if somebody's just a jerk, like they don't like people that wear red shirts, I can't stop them from being a jerk that doesn't allow red in the workplace. So sometimes we will have to be checked about whether or not what our complaint is actually a legal complaint, or if it's just us being sick of somebody who's a real jerk in the workplace, which means it's time to find a new job. What if you're not satisfied with how they dealt with your situation? Usually at this point, you need to hire an attorney. In other words, like, or find an advocacy group to help you. There's a lot of cool stuff online that you can do and find. You know, lots of law schools have really great advocacy clinics. I guess right now we're not able to walk into those, but I bet there's some great online resources. But you need to, again, at this point, perhaps consult with an attorney about whether or not your complaints are protected under the law, and write some more emails with specific wording, such as, like, I believe I'm being discriminated against based on gender, and you haven't done anything to take away this supervisor or perpetrator who's continuing to do it to other people. And therefore, I think that there may be a case for negligent retention against you in the future because you're allowing this bad actor to stay in the workplace just because he or she brings in business. I mean, we all know the person I'm talking about. They exist across a broad spectrum of companies. People that are just terrible, terrible, terrible to everybody in the workplace, or they're bullies, or they're sexist, or whatever it is, but the company keeps them on because they, you know, were like somebody's bro from a fraternity or some terrible reason like that. Okay, sorry, not against the Greek system, just giving a generalized comment. Okay, working for a very small company, what do you do when the person harassing you is the one you're supposed to go to for help? Case law has said that companies you are not forced to talk to the person who was your aggressor. As a matter of fact, case law has shown that speaking to your company forcing you to talk face-to-face to an aggressor about what has happened to you is also a form of retaliation and harassment. Go above that person. So whether it's the CEO of the company, in other words, like, if your person's below the CEO, go to the CEO, or any member of senior management. So if there's somebody else who exists there who's also commensurate level of management as the CEO, perhaps there's also a company president, perhaps there's a CFO or COO, you need to report it to somebody other than that person. Also, if you're in a very, very small company, this is crazy, but some companies, if they're under 5 employees, they don't have to conform to some of the labor and employment protections under the law and the Constitution. So you want to check with somebody about the number of people employed in your company. Okay. As an employee advocate, how do you suggest empowering people to take action for themselves? At what point would you then, as an advocate, do it for them because you see a pattern, if you do it at all? I do this. This is my job. The point of this seminar is to enable you to do it without having to pay a lawyer. You know, I switched from defense to plaintiff side work because I believe in advocating for individuals. My office works for Me Too, the Me Too movement. We work for the Transgender Law Center. We have lots of cases pro bono. But for the most part, because of the way I feel about it, but at a certain point, after you've done all the steps that we've talked about today, you know, you've used specific language and said, I believe somebody's sexually harassing me, and there's not a full investigation. You do need to reach out to an attorney. Some firms will have small consulting fees you can pay to either evaluate your claims and tell you, you know, maybe it's not what you think it is, or to tell you it is and to give you some language and words to say. And then frankly, like, the next step would be engaging an attorney either on a fee basis or contingency fee basis, especially if you've been fired. If you've been fired, more law firms will take things on contingency more than when you're still currently employed. But you're going to need to, you know, my firm takes those cases, as do other firms. You know, this is to try to help you do it before spending lots of money on lawyers. How do you proceed in cases where there is gaslighting involved? As in, I think you should have clarified with me first, or we were discussing this and you didn't say anything about it then. This is where I believe note-taking really comes in handy. If you have somebody who is changing the words on you or constantly moving the ball, every single time you have a conversation with them, you need to memorialize it. Every single time. Or you need to say, you can even go to human resources and say, I'm having this problem with this person changing the goalpost for me constantly. I need your permission to tell them I'm going to record conversations every time we have them, or that we're going to put it in an email every time we have them, or we'll do it on Zoom and you'll record it every time you have the conversation. Be persistent about advocating for yourself and use evidence against them. In other words, writing it down, sending it back to them. I just met with you in a one-on-one, and here's the direction you gave me, blah, 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 and blah. Here's how I'm going to do it. Honestly, if I get like 10 of those responses where the other person acts nuts in their response to you after you've just talked to them, then that's going to be good evidence of them discriminating or harassing you. I don't know what the underlying reason is, right? I mean, I want to be clear. Gaslighting is a little bit like when I'm talking about the asshole thing, like somebody doesn't want to take accountability. I don't know if I can always link that to a protected, protected troublemaker move in the workplace, but we can still deal with them. And certainly perhaps that fits into the bullying category under negligent wrongful retention of a bad employee. What do you do when the bully is the owner? You get a new job. I'm not trying to be flippant. I'm just, you're not going to get very far with that, unfortunately. And we can talk more offline about what that means. But unless you have a very specific job or career that only, you can only work for this one company because you have a degree in macular neurobiological splicing. I mean, I'm just making something up. But unless that's the only company you can work for in the world, you need to look for a new job. You can still report them. Let me be clear. We've had cases, many instances of CEOs or owners being unseated by boards. But if there's not a board and it's an individually owned company, a lot of times they're not subject to some of these laws we're talking about because they're so small. But if there's a board of directors and there's an ongoing problem and there's outstanding liability, then they can unseat that person. It's a hard fight though, as you can imagine, but I've done it for people. Follow up to the questions about investigations. If this situation is between me and HR, will my boss hear about it and or other colleagues? I need some clarification. Are you asking me if the situation that's discriminatory is coming from HR towards you, or are you asking me about your reporting this to HR and whether or not other people will be involved? I need more information to answer that question. So perhaps why don't you follow up in these questions here and just say you're following up on that. Do you have any advice for discrimination and retaliation towards employees with children? Well, absolutely. Your parental status is generally protected in most states in the nation. Some states have less protections, and a lot of times they can be intertwined with gender discrimination claims. In particular, I would say this. Be specific about leave. I'm going to tie this into coronavirus right now for a minute. One of the things that's happening under the coronavirus is that employees are having to stay. We don't have childcare, right? I have 2 children in this house right now who are running across the ceiling, which you probably can't hear, but I can quite distinctly. Under Fmla Leave, the Family Medical Leave Act, under the coronavirus provisions, you are allowed to take up to 12 weeks off right now to care for your children because they're home with you during the coronavirus and you have no other childcare. When you start taking protected leave, such as an FMLA leave, that actually protects you a little bit about a return to work. In other words, that'll give you greater protections during this time. Now, I want to be clear, there is a double-edged sword to taking protected leave right now. So there's expansion of leave in most states. You can go online and Google, what do I do? I can't return to work because my children are home from school. I don't have childcare. The reason it's problematic is that companies can also say that they financially can't afford to not have you there, and they could still terminate you because of what's happening with the economy. So under the law, you have to hold somebody's job open until they return back from these protected leaves. However, if the company itself is having all this damage occurring because of the economy, they could technically argue that financially they couldn't hold your job open for you. Now, that's one way to approach it. Another way is to go aggressively into the situation by saying, I don't want to take this leave. I'm really struggling. I'm afraid that if I take leave that you would then retaliate against me. Or maybe I'm trying to be gentle about these words. You can talk to your employer in an email format about the fact that you're struggling and that you might have to take leave, but you don't want to because you understand what that will do to the business. How can we work together? But mention that you might take leave or mention that you might need to take leave. Even those mentions will protect you. And what that means is, even if you don't actually take the leave, it will still force your employer to accommodate you more because you don't have childcare at home, okay? The discrimination against employees with children have to be more fact-specific discussion about how that's affecting you and when and what it is doing to affect you. I have a case like that right now in my office where somebody said, oh, you're not married to this job, you're married to your kids, and it's ridiculous. Sorry. Okay, makes me upset. Okay. What do you suggest if there's no HR and no employee handbook, but you are consistently being bullied and discriminated against by your boss? In this case, the boss of his CEO, who is the CEO of a 25-person startup. What will be first step or 2B? Okay, so I deal with this all the time because I'm a labor and employment attorney in the Bay Area, and startups are always doing stuff wrong. It's just they just constantly are. So you can look to the internet. You can look to comparable employee handbooks. Like, in other words, like there are requirements under the law. The law says you have to investigate claims of sexual harassment or discrimination to your greatest ability possible. That's the law. So you can go look at if you're in California, I don't know where you are, but usually the law, very easy to Google, like, what is the law in the state of Delaware with regard to discrimination in the workplace? What are the employer's obligations? Find some language like that. And let me just tell you this, whether or not it truly applies or not, it's generally enough to give them notice. In other words, like later on in litigation or later on when a lawyer steps in, if you need it, that's going to be enough notice to the employer to say they need to do something and they needed to do it now. So take samples from other employee handbooks, Google what the state or local requirements are of an employer when there's a report of discrimination, and send an email about that. Also, like as I was saying, if it's the CEO, then you need to go to the next person over, whether it's the COO or CFO, and memorialize it, send an email. I know this is all scary, but again, if you're using protected words and requests, then you will be protected from retaliation or discrimination if their next step is to fire you or to give you a bogus PIP. So if you know something happened and your boss denies it, and then HR says it's closed, what leverage do you have? I mean, that's a really big question. Things don't usually happen in a vacuum, like where there's smoke, there's fire. In other words, like if somebody is I mean, I'm gonna extrapolate out from this, but like somebody is like a real jerk and they do stuff like this, like they deny that they did that. It doesn't really matter if you have other people in the workplace. One place to look, and this is once you get into litigation, this is not really germane to this conversation, but it could be, which would be other former employees, people who have left the company who are like, oh yeah, that guy, all he does is lie, or this is what he did with me. Circumstantial evidence can prove patterns of people. And that's the way I do my job a lot, which is, people are not usually jerks in a vacuum. You're not like a jerk to one person. You're not discriminatory to one person. You're discriminatory to multiple people over time. And so we demonstrate that by showing that a particular CEO only gives promotions to males or only gives promotions to people that are white or whatever it is. That person doesn't usually do their bad behavior in a vacuum. So we would use pattern and practice to show through testimony from other people or through other actions that person is generally known to be dishonest. And you can point out those other instances to the extent that you know about them to HR, which is like Or you could do what we talked about, which is you take the contemporaneous notes. Like, I talked to him and he said, I hate insert protected group here. And that's happened on this date. And here's my notes. And I need you to do something about it because he did say it. And other people have heard him say discriminatory comments about that group of people in meetings. What about the time you said blah, blah, blah at the company picnic, you know? Okay. Our severance was tied to signing an NDA. Are there any instances where the NDA would be void? For instance, if the company goes out of business. You want to have lawyers review severance agreements before you sign them. I mean, generally speaking, the only way that you can avoid a severance agreement is through fraud. Like, in other words, like, I have a case right now where somebody signed a severance agreement and the company had said, oh, we're going to pay you based on your vesting schedule. And we found out later that the company had altered the vesting schedule. So that was fraud. In other words, like, the terms of the contract itself were not valid. They had been changed or altered to defraud her of her equity being vested in the appropriate manner. If the company goes out of business, they still have grounds to come after you. In other words, like, if you had a severance agreement with a company that went out of business, you know, and then 2 years from now you went out on a campaign against, you know, saying they paid you all this money to exit the company because I'm trying to think, had a sexual assault charge, they still have a cause of action against you. So even if they don't exist now, they can still sue you in the future. So I wouldn't rely on them going out of business to invalidate an NDA. Again, only fraud will invalidate an NDA. Okay, my partner works in an office with 4 people total. The boss is constantly yelling, micromanaging tasks at all times, and pressuring employees not to take vacation. There's no HR. Well, so if you have 5 employees or less in the state of California and many other states in our nation, you cannot be held to the same standards in terms of protection under the law. Now, there is something that does apply to you. It's called wrongful termination and violation of public policy. And there's also something this is in California only, though I want to tell everybody that, but you could still use it in other states, I believe, or constructive wrongful termination and violation of public policy. I know these are like big phrases and it sounds overwhelming to hear them, but what you should do is so the partner should start memorializing the interactions and should start talking to the boss about them. In other words, to the best of his or her ability. In other words, talking about the way the yelling is affecting the morale in the office, or talking about, let me try to figure out how to best answer this one. You need to be documenting what's happening. You would need to be emailing him about it over time. And if somebody makes you quit your job, you could still have a constructive wrongful termination claim against them and possibly a hostile work environment claim. They need to start documenting what's happening, and they do need to provide the owner with notice about the way it's affecting them. Like, in other words, like if the owner is saying don't take vacation and is yelling at people and the person's having panic attacks and anxiety, they should disclose those physical and mental and emotional issues to the boss, and then perhaps take disability leave to prove the point. I mean, I'm riffing here because this is a tough situation because it's under 5 people, but I would suggest that they start going to a doctor or documenting the way they feel about it. And if it gets really, really bad, then they can say that they had to quit their job because of the work environment, but you have to give notice to the boss of those issues prior to doing that. You can't like sneak attack someone and say, these are all problems for me and you made me sick mentally and emotionally, but I didn't tell you. It's hard in those small offices, so I understand that struggle. Can you give examples of gaslighting in the workplace? That's just such a hard question. I feel like I want to answer you, but I feel like that's just too broad to try to do right now. I don't think we have enough time for that. What do you do when you keep being the witness? There's an employee whose inappropriate comments to others keep happening in my presence. The last time I was the only third person Severy knows I am the witness. The employee keeps making the same poor choice though. I mean, what happens, what do you do when you keep being the witness? I mean, there's nothing for you to do unless you're being discriminated against because you're the witness. In other words, like, you just need to keep being honest and open about the interactions and what that person's saying to you. Unless your company is then discriminated against you for participating and being the witness, there's not really much to do there. If you are then retaliated against, then that's something that's actionable. Can you mention you want to file an EEOC claim to get them to take you seriously? Sure, that's not a bad strategy. An EEOC claim, or in the state of California, a FEHA claim, which is also the equivalent of an EEOC claim. Most states have their own interior claims. In California, it's the Fair Employment and Housing Act. Most individual states have something aside from the EEOC that you can file under as well. And that will show them that you're preparing to file for litigation. That is actually a good tactic. It's dramatic though, and it will make them mad. So if you want to keep your job, you have to weigh that. If HR doesn't handle it well, can you go above them and notify the president of the company? Absolutely. I always think that going up the chain is a better, more effective way to get things done. As long as you don't think that's going to, negatively affect you, and these are all fact-based things, right? So it's a fact-by-fact basis. Okay. I want to answer this first person's question now. I'm going to go back up to the when I was furloughed a month ago question. When I was furloughed a month ago, I asked my boss if anyone else in our department was affected. He responded that there was one other person who was furloughed and that he didn't furlough another colleague because he didn't want to put additional stress on her while she was pregnant. What are your thoughts on this comment decision making, and is there anything I can or should do? Well, I mean, he answered you, right? And he didn't say, she's in a protected class, so arguably he would be making a decision that he probably thought would relate to liability later if he laid off or furloughed the pregnant person. I mean, I think that if it makes you feel uncomfortable or that you are not being protected fairly, that it's always fine to make that comment or follow up to your boss. It's always fine to say, I don't want any of us to be treated any differently based on whether or not we are pregnant or a man or a woman or gender neutral or gay or straight, I think it's fair to always respond to your boss or employer and say, I just want to make sure everybody's being treated consistently, fairly, and the same. Frankly, that's what we all strive for in the workplace, right? We don't need to be treated better than simply because we can have a baby. We need to be treated equally. So I think it's fair to go back to your boss and ask to make sure that you are treated equally to anybody else in the workplace, whether or not you're having a child or any other reason. Yes, Samantha.
Hey, I was just jumping in because we only have time, I think, for one more question, but I saw one pop up that I really like that I think a lot of people have been asking. Sarah just asked, is there anything more you can share about parents and how they can advocate for themselves right now during coronavirus and how they're, they have all these work from home expectations and maybe no childcare?
Sure. We did talk for a moment about the Fmla Leave option, which is available most places. I can tell you that the #1 way to avoid having to go into the workplace is to make a statement about the fact that you're fearful for your life and or for loss of life and or related significant injury. I know that sounds dramatic, but it is a dramatic time. If you communicate those types of fears to employers about time requirements and or we have a situation right now where somebody's attempting to make an employee go back to work prior to shelter in place being lifted in his county, you need to make the statements affirmatively. So what you have at your disposal are Medical Leave Act provisions that have come down specifically related to the coronavirus for parents. Go look those up, find out what they are for you locally, so that it can change from county to state to federally. And you want to look at all three. By way of example, I'm in San Francisco, so I know that our local requirements are much nicer to parents and people of diverse backgrounds with different requirements at home right now than it might be in a different county. So look at your county requirements, look at your state. Also, some other things to remember are this. If somebody tries to get you to go to a different county and your shelter in place in your county is one thing and theirs is different, you do not have to go to the other county. Meaning, like, if you're still under shelter in place, but your job is not, Like you're in San Francisco and Santa Clara is open, you do not have to go to Santa Clara because you are still sheltered in place. That's just some advice I'm giving people. But with regard to the working parents, you need to document specifically for your employer how much time out of the day you need to be spent taking care of the children. You need to document your concerns about the health and safety of your family if somebody's trying to require you to go back into work physically. And then also take advantage of local leave act and laws, with keeping in mind that I want to be very clear about this with parents. The fact that the economy is tanking means that employers have ammunition in their belt to say that they're going to fire you because they can't financially sustain employment without you. That is total bullshit if you work at a big company. Okay, I'm just going to be like really clear here. You can take FMLA leave and take leave to watch your kids if you need to, if you're at a big company, because 9 times out of 10, like unless it's Uber, they can't say financial drama right now. If it's a smaller company, you need to formulate emails that say, I've looked at leave requirements. I might want to try, I feel like I might need this, but I'm afraid that you might fire me if I take it, and set them up by having that conversation. Because the way that I would handle that is I would then come back if they discriminate against you and say, they're discriminated against you specifically because you talked about taking this leave. All right, that's it.
Perfect. Thank you so much, Claire, and thanks to everybody who joined us. As I mentioned, we'll be sending out the recording of this later today, as well as Claire's contact info. So if you have any additional comments, questions, or concerns, feel free to reach out to her directly. Thanks so much, everyone. Have a great week.
Bye.
Bye.